Heydon's case, heard nearly 450 years ago, is one of the foundational cases for the branch of law known as statutory interpretation. A branch of law which went from strength to strength in the 20th century and which shows no signs of slowing down in the 21st. You can't be a lawyer in the 21st century unless you're proficient at statutory interpretation. And you can't become proficient at statutory interpretation unless you understand Heydon's case. We start with a simple proposition. The law is made of words, and the words are written. For 1,000 years, the basis of law in England and in those civilisations founded by England has been the written document. When the courts make significant decisions, they write down the verdict and the ratio decidendi, the reasons for deciding. When the Parliament makes laws, it makes them in the form of a document, which then goes before the Crown for assent. Written laws have an obvious value in that the words written down never change. A Parliament can write down a law and we can come back 100 years later and still see exactly what law the Parliament made, because it's in writing. At the same time, however, language is never as precise as we'd like it to be. How many times, even in your own life, have you written a text message or an email which you thought was completely clear, only to have the recipient thoroughly misunderstand your meaning? How many times have you received a message or an email and had to stop and think, what do they mean? The fundamental task for our courts is to resolve disputes between parties. Very often, those disputes arise because the two parties are looking at a document, whether it's a statute or a contract or an earlier judgment or some other document, and they disagree as to its meaning. Over time, the courts have developed a series of well-understood rules and approaches setting out how they go about the process of determining the meaning of written laws. This is incredibly useful because it makes the courts predictable and allows lawyers to give good advice. They can say, well, I think the court would be likely to attach this meaning to the words, and they can do that because they know the rules the courts will follow. That's statutory interpretation. Heydon's case established one of the earliest and yet most enduring rules of statutory interpretation. It's known as the Mischief Rule because, as we'll see, it involves asking what mischief, what problem was the Parliament trying to correct, and then reading the legislation in a way that advances that meaning. So, let's dive in and see how it works. We're going to start by thinking about the very idea of legislation. Initially, during the reigns of the Norman kings from 1066 until 1135, and then the Plantagenet kings from 1154 to the 15th century, the king was essentially a dictator, ruling by divine right. They didn't have it all their own way though. In 1215, King John had to capitulate to rebellious nobles and sign the Magna Carta. In 1264, the crown was temporarily overthrown by a noble named Simon de Montfort, who was the first to assemble anything like a modern parliament, including commoners as well as nobles. In those early days, though, parliamentary assemblies really were just a matter of advisors to the king, and the king continued to hold all the real power. There was a continuing creative tension between the crown and the nobles, the churchmen and the commoners in the parliament. Initially, the House of Commoners had no role in legislation at all. If it identified a problem, it would petition the Crown and the House of Lords to pass laws to fix the problem. A turning point came in the year 1414. There is a bill still in existence from Parliament that year, with a note saying that the House of Commons had agreed to amendments made to the bill by the House of Lords. Why is this so important? Well, there are two reasons. First, it shows that by now both Houses of Parliament were equal participants in the process of making law. Statute was now a parliamentary thing rather than merely an action of the Crown. Second, we can see that by this point both Houses of Parliament were paying a lot of attention to the actual wording of the statute. We know this because the Lords took time to make amendments to the bill, and then the Commoners agreed to those amendments. The next player in this story is King Henry VIII, the one who famously had 6 wives. He took the throne in 1509. Before we get to that though, the period between 1414 and Henry VIII taking the crown was particularly turbulent. A series of civil wars known as the Wars of the Roses between two rival royal houses, the House of York and the House of Lancaster, went on from 1455 until 1487 and resulted in over 100,000 deaths, which is a lot when you consider that the population of England at the time was only about 2 million. The Catholic Church and its Pope, who were the other major source of power in 15th century England, took virtually no role in the Wars of the Roses. So by the time King Henry VIII came to power, he knew 3 things beyond all doubt. First, it was crucial to have a clear line of succession, a legitimate male heir, and preferably a spare. Second, there should be only one major centre of power in the country, in order to avoid conflict of the type they had seen between the Yorkists and the Lancastrians. Third, despite the fact that he had been quite a devout Catholic, he formed the view that the Church could not be trusted in a crisis. They had been happy to let the war roll along. Henry initially concentrated on the first of these 3 principles. He married Catherine of Aragon, a Spanish princess who had briefly been married to his older brother Arthur, who had died before he could take the throne. The marriage was important politically, but quite long-lasting too. They were betrothed in 1503 when Henry was still just 12, and they married in 1509, just before Henry's coronation. They remained married until 1533, so 24 years of marriage and 30 years since their betrothal. The difficulty was she was unable to produce an heir. She had 5 children, including 3 sons. 2 of those sons were stillborn, and one, also called Henry, died at 7 weeks of age. One of the daughters, Mary, later Queen Mary, did survive, but Henry needed a son. Eventually, Henry formed the view that Catherine, who by 1425 was already 40 years of age, would not produce a male heir. He began the process of seeking an annulment of the marriage on the basis that the Bible declared a marriage void if a man married his brother's widow. The Pope, however, had more pressing concerns. Catherine's nephew, King Charles V of Spain, had just successfully invaded Rome. The Pope could not afford to antagonise him further by putting his aunt off the throne of Britain. Henry instead appointed his supporter Thomas Cranmer as the new Archbishop of Canterbury. Cranmer granted the annulment in 1533, effectively breaking the Church of England away from the Catholic Church. Henry VIII was excommunicated, cut off from the Catholic Church, but by this point that was meaningless. You're probably wondering by now where the statutory interpretation bit is in all of this. I promise we're coming to it soon. So, Henry has essentially formed his own church, but the monks in England were still often loyal to Rome. And what's more, the Catholic Church was a massive landholder. Not just churches either, but other lands like farmlands. Henry had therefore stumbled into the very situation he wanted to avoid, having 2 rival centres of power in England. He moved quickly, and his supporters in the Parliament passed the Suppression of Religious Houses Act 1535. The main effect of this act was to take many of the smaller religious houses and make them the direct property of the king, who was also the head of the new Church of England. The excuse used was a suggestion that these houses had become places of unthrifty, carnal and abominable living. This obviously caused outrage among the churchmen, but it was also concerning for the thousands of ordinary Englishmen who were small-scale yeoman farmers farming land which belonged to the church. They were worried that they would be kicked off their land. To reassure them, the Act included a provision which said, translated into modern English, such persons as have leases for time of life or years, whereupon is reserved the old rent, shall have and enjoy their said leases as if this act had never been made. In other words, those farmers were not going to be disturbed from their prior arrangements. The church saw this legislation coming, and before the Parliament had an opportunity to pass it, they began handing large areas of land to strong supporters of the church, with long tenancies attached. The Parliament realised what they were up to, and included a provision which said, crafty and fraudulent grants and leases made by any of the said chief governors of such religious houses within 1 year next afore the making of this act shall be utterly void and of no effect. So the combined effect of the two provisions was that if you were a long-term tenant, then your position would be secure, but if you were a newcomer put in there by the church as a dodgy way of shoring up support, then the act would not protect you. Now, slight preview, but the first of those two provisions is going to be the source of dispute in this case. It set out in essence two criteria. You had to have either a lease for time of life, so a lease that would last as long as the leaseholder lived, or alternatively, you had to have a lease for time of years, so a lease that had a term, but a long term. Just keep that provision in mind. It's going to be important. So now at long last we can come to the actual dispute. There was a church manor called Ottery in Devon in southwestern England. Ottery had various lands attached to it, and some of those lands were farmed by a man named Ware and by his sons. They did not have a lease as such. Instead, they had a different type of title, very similar to a lease, called a copyhold. Back in those days, the title deed itself was evidence of the ownership of land. There was no central registry such as we have in Queensland. The only way to show that you held title was to have the deed. Copyhold was interesting because the copyholder did not get the deed. Instead, they got a copy of the deed, and their copy of the deed effectively served as their right to be on the land. So in this case, Mr. Ware had been given a copyhold title that he and his sons could exercise throughout their entire lives. Copyhold did have one drawback, which is going to be important in this case. While the copyhold was expressed to be for a period of time, in reality, the title holder could demand the return of the copy of the deed at any time they liked. So there was really not a lot of security for the copyholder. Some of you can probably see where this is going now. The church obviously decided that the Ware family was not sufficiently on their side to be trusted. So the church called in the copy. Basically, the church just took the Ware's land away. Instead, the church granted to Heydon a lease for 80 years. The lawfulness of this conduct ultimately ended up in court. The first thing to understand is that the court was not going to be able to resolve this dispute by reference to the common law. By this time, it wasn't yet clear that statute was superior to the common law, but in the context of the time, it would have been very clear indeed that the court must resolve this dispute by reference to the statute. The statute was very clear indeed about Heydon's position. This was very clearly a grant or lease made by the chief governor of the religious house within 1 year before the making of the Suppression of Religious Houses Act. It was therefore utterly void and of no effect. So Heydon pretty clearly was going to be ejected. But it didn't necessarily follow that the Ware family could have their copyhold returned. They had to satisfy the other provisions of the statute. Let's pull it up again. It says, such persons as have leases for time of life or years, whereupon is reserved the old rent, shall have and enjoy their said leases as if this act had never been made. Now, if we read this proposition like a lawyer, three things spring immediately to mind. First up, the provision relates to leases. It doesn't specifically say anything about the position of copyholders. Copyholders had something very like a lease, but their rights were slightly less. A leaseholder can't just have their lease taken away, but a copyholder can just have their copyhold taken away. So, was the provision just for leaseholders, or should the word lease be given a broader interpretation to include copyholders? If the word lease was given a narrow interpretation, then the heirs would have no right to return to the land. If they overcame that first hurdle, they would then need to show that their lease was for time of life or years. Could they show this? On the one hand, they could show that they were given the copyhold for Ware's life and the life of his sons. But it seems like these were empty words, because the copyhold could be demanded by the landowner, the church, at any time. And that, of course, was exactly what happened. So did they really have a lease for time of life or years? Or did they really just have a copyhold with a maximum term of the lives of 2 generations, but which could actually be ended whenever the abbot of the church manor of Ottery decided? And if they didn't have a lease for time of life or years, then would the statute protect them? If they overcame that second hurdle, there was still the issue of remedy. The provision says they shall have and enjoy their said leases as if this act had never been made. But those two halves don't necessarily go together. You see, if the act had never been made, then the wares would still have had copyhold, it would still have been taken off them, and it would have been given to Heydon, and there would have been nothing they could do about it. So, if they get to have and enjoy their said lease, well then they get the land back. But if they proceed as though this act had never been made, then they lose their lease. Which was it to be? You can see now what I meant at the start of this case note, when I said that language is often not as precise as we would like it to be. Here is one single provision, a provision which on first reading seems fairly straightforward. But when we start to read that provision carefully, it's actually quite ambiguous. There are 3 different clauses within the provision which could result in the wares losing their land. So how does the court decide on the actual meaning of these provisions? We could say, well, we'll just leave it to the judges to decide. But that has a few problems with it. First, it means that the meaning of the law might be inconsistent between 2 identical cases simply because one judge decided one way and another judge decided differently. Second, building on this, our system of laws is built on the notion of stare decisis, that is, like cases should be treated alike. The whole idea of the doctrine of precedent is to establish a situation where similar disputes have similar reliable outcomes that do not depend on the idiosyncrasies of any particular judge. So one way or another, the court was going to have to establish rules so that everyone knew the approach they would be taking to interpreting the words of statutes. The judge in this case, Sir Roger Manwood, the Chief Baron of the Exchequer, set out to lay down some rules. It seems that Sir Roger started out from a principle which is both simple and profound. When people use words, they mean something. So, if the words are confusing, we can often work them out by asking ourselves, what did this person mean? What's the context? What were they trying to tell me? Fundamentally, when the Parliament passes a law, the Parliament collectively means something. The Parliament is trying to act, to pass an act, to achieve some purpose. And so it makes sense that the words in the act are all meant to advance that purpose, or at least they're not meant to defeat that purpose. From that relatively simple starting point, the Chief Baron established 4 considerations, which together are referred to as the Mischief Rule in statutory interpretation. Consideration number 1. What was the common law before the making of the Act? Remember, Sir Roger was making this ruling at a time when most law was common law. Most law was judge-made. Statute was still quite a new thing. So if the Parliament was making an act, Most of the time, that would mean the Parliament was starting out with the common law, in this case the common laws relating to land tenure, and then modifying it. That being the case, it helps us understand the statute if we understand the underlying common law, which the statute was intending to modify. Consideration number 2. What was the mischief and defect for which the common law did not provide? So this is a slight development on that first consideration. Essentially, we're saying that the common law must have been insufficient, because if the common law was sufficient, why would the Parliament bother passing new laws? So if we can understand what gap, what mischief, what defect the Parliament was trying to correct, we can read the words of the statute in that context. Consideration number 3. What remedy the Parliament hath resolved and appointed to cure the disease of the Commonwealth. Coke was using the word Commonwealth there in the sense of the common good. So having looked at the common law principles and identified the gap in those principles, we then ask, how was the Parliament trying to fill that gap? What was its policy or its general approach? Finally, that brings us to consideration number 4. The office of all the judges is always to make such construction as shall suppress the mischief and advance the remedy, and to suppress subtle inventions and evasions for the continuation of the mischief, and pro privato commodo for private convenience, and to add force and life to the cure and remedy according to the true intent of the makers of the act, pro bono publico, for the public good. Now that last consideration is often merely quoted as make such construction as will suppress the mischief and advance the remedy. I've done that myself in shorter case notes on this case. It's a pity though, because the long form is so much richer. The ruling is not merely to advance the remedy set down by the Parliament. It's also to ensure that the intention of the Parliament is not defeated by tricky arguments, by subtle inventions and evasions. The court is to add force and life to the cure and remedy. So any court applying the Mischief Rule should begin by asking what the common law is, what gap the Parliament has identified in the common law, what general approach the Parliament has taken to correcting that gap, and then the court should read the legislation to positively advance that policy, not allowing it to be defeated by tricky interpretations. That's the Mischief Rule. So how did they apply it in Heydon's case? The common law rule they identified was that religious and ecclesiastical persons might have made leases for as many years as they pleased. So if churches owned land, they had the right to lease the land to whomever they liked for as long as they liked. The report goes on. The mischief was that when they perceived their houses would be dissolved, they made long and unreasonable leases. So when the church members saw that Henry was coming after them, they tried to secure their influence by making long-term leases to their favourite supporters. That was the mischief in this case. The third step, Parliament's policy to deal with the mischief, is where it gets a little more complicated. The Chief Baron said that the remedy was that all leases of land, whereof any estate or interest for life or years was then in being, should be void, and their reason was that it was not necessary for them to make a new lease so long as a former had continuance, and therefore the intent of the Act was to avoid the doubling of estates, and to have but one single estate in being at a time. If the copyhold estate for 2 lives and the lease for 80 years shall stand together, here will be the doubling of estates, which will be against the true meaning of the Parliament. Now this seems a bit odd, and a little bit at odds with what the Parliament actually said. The Parliament referred to crafty and fraudulent leases. It wasn't a matter of preventing the doubling up of estates, preventing 2 people from having a claim over the same land. Besides, in this case, there was no doubling up because the Ware family had their copyhold terminated before the lease was made to Heydon. But at the end of those first 3 steps, the interpretation was at least that before the Act, the Church could issue leases to whomever it liked, for whatever term it liked, The mischief was that once they saw their church manor was to be dissolved, they made long and unreasonable leases, and the intention of Parliament was to prevent those leases. The court still needed to decide whether that rule would apply to copyhold, and there seems to have been great dispute among the barons in the court about this, and it's not hard to understand why. The barons themselves would all have been landholders, and so they would have had a very clear understanding of why it was valuable to them to be able to issue a full lease in some circumstances and copyhold in other circumstances. The last thing they wanted was for the distinction between those two types of land tenure to be removed. They didn't want copyholders being able to claim some greater level of security of tenure, and so, as Coke says, it was debated at large in what cases the general words of Acts of Parliament shall extend to copyhold or customary estates. The conclusion they eventually reached was that Acts of Parliament which referred to leases could extend to copyhold, but only if there was no prejudice to the rights of the lord of the manor. In Heydon's case, there was no lord of the manor because the church manor had been closed down, so the rights could extend to the copyholder. The outcome then was that Heydon's lease was invalid and that the Wares had never lost their copyhold. Of course, we don't really remember this case because of what happened to Heydon and the Wares. Remember it because of the 4 considerations established by the Chief Baron, which together make up the Mischief Rule. Let's look at those again, cut down a little for convenience. What was the common law before the making of the Act? What was the mischief and defect for which the common law did not provide? What remedy did the Parliament resolve upon to cure the disease? Make such construction as shall suppress the mischief and advance the remedy, and suppress subtle inventions and evasions for the continuation of the mischief. We can summarise all of this pretty simply, work out what the Parliament was trying to fix, and read the words in the statute as part of an attempt to fix it. This rule has been incredibly enduring. While preparing this case note in late 2024, I looked up recent citations of this rule and found that within just the past 5 years, it has been cited in Supreme Courts in Victoria, Queensland, Tasmania. It was even cited in the High Court of Australia as recently as 2019. It's been cited in superior courts in India, the Republic of Ireland, Fiji, Jamaica. Quite amazing, really. The law, however, rarely stands still. In Australia, despite these recent citations, Heydon's case is now most important as a foundation for a more recent approach to statutory interpretation called the purposive approach. You see, the Mischief Rule, as we've discussed it in this case note, is really quite limited in scope. It basically assumes, because of the era in which it was made, it basically assumes that the bulk of law is common law and the purpose of the statute is to slightly modify or correct that common law. They could not have imagined a law where most of the law is now statutory, made by Parliament, and it's only in a few places that the common law sneaks through. Parliaments now sometimes override entire areas of common law. For instance, when states implemented criminal codes and did away with the old common laws of crime. Parliaments also make laws in areas where there is no common law, or they make laws simply in order to implement a government policy, rather than because they see a specific defect in the common law. So you can see that to remain relevant, the Mischief Rule had to evolve. It could no longer be assumed that the common law before the passing of the Act was actually relevant. It could no longer be assumed that Parliament's purpose was to cure some defect in the common law. But it could still be assumed that the Parliament did actually have a purpose. It might have been a broader purpose than merely correcting the common law, but the Parliament, when making laws, had a purpose. It was trying to achieve something. So the modern development of the Mischief Rule is called the purposive approach to statutory interpretation. It calls upon courts to identify the purpose that the Parliament had in passing a statute, and then to interpret that statute in a way that best advances that purpose. This is still a contentious process, but it traces its origins back to a small church manor in a southern district of England and to a political conflict which arose because King Henry VIII really needed a son.